Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 10th, 2026. We have 8 bills on the docket. We're going to start off with Senator Hayes with Senate Bill 815.
Record, okay. Senator Antonio Hayes, representing 40th Legislative District in Baltimore City. Today, I'm presenting Senate Bill 815. Just to give a little bit of context about Maryland Correctional Enterprises, and it's weird that it was assigned to this committee. Usually it's over in B&T, but we'll go with it, right? Because it's really a procurement thing more than anything else. But just to give a little bit of history on MCE, once the abolishment of the 13th Amendment that freed slaves, there was a need to supplement that workforce. In doing so, agencies like MCE was created all over the country. And in I believe in the 1960s, the federal government made it against the law to transport prison-made goods across state lines because of the exploitation of the prisoners. And so what many states did, they created an artificial audience to purchase goods and services from these organizations like MCE around the country, and they mandate in state procurement law that state agencies must purchase services from MCE. The goods and services and the skills that are afforded to those who are in prison should not go away. I think it's a great opportunity especially for individuals that looking to reenter back into the community to gain the skills that are provided. Where I take issue is I don't think that we've evolved as a system. And so this bill essentially asks that the department partners with, and we have an amendment to say specifically with the USM in order to look at what other states are doing. Other states are finding more creative ways to upskill their prison population and to have some of the proceeds go back into the communities where the offenses took place. And so that's essentially the bill, and I hope that this committee will give a favorable report for Senate Bill 815 with the amendments.
Excellent. Thank you very much, Senator. Questions from the committee?
No question? No.
Senator West.
Of course.
Thank you, Mr. Chair. Thanks for bringing this bill. I've been interested in reentry and making it easier for people who reenter to be successful for a long time. We have a study commission that's working, I think a multi-year study commission that's actively, I just got another email from them this morning. Their next meeting has been scheduled. Cool. My problem is it's rare that I can attend these meetings because of other conflicts. So this is good. But my question as I read the bill is, is our Department of Public Safety and Correctional Services going to be able to come up with good information on what they're doing in Maine, Ohio, Kansas, and California? Why those 4 states?
That's why we're asking the USM. So we have some of the greatest institutions of higher education that this nation has ever seen. Many of them have the research and the expertise to do this evaluation. I agree. This is not the role of our Department of Public Safety to do this type of extensive research, but with the collection of the 13 institutions that make up the USM, I think we do. I will add that the bill has a fiscal note because there will be a cost to partner with the institutions, and I'm working with our colleagues in Budget and Tax to make sure that we're able to get this achieved. And we believe that it can be achieved with our institutions at $150,000, not the $200,000 level that the fiscal.
And you chose those 4 states because you've read something somewhere that those 4 states have?
Yeah, no, absolutely. Since the implementation, like I said, all of the states have implemented institutions like MCE, which used to be called state industries, by the way. Right. And these are some states that have some significant, they have updated their practices based off of emerging industries. Like I think in Massachusetts it is that one of our colleagues has shared, they're actually doing coding, and one of the persons that's behind the bars is making roughly about $140,000 a year. Now that doesn't go to that individual, but a part of the proceeds from that individual go back to the community where that person offended.
Cool. Okay. Thank you.
Thank you, Very much. Thank you, my brother. Literally, you know.
Yes.
But I commend you for putting this bill in. It's a good bill. We need to start focusing more on rehabilitation, on preparing people after, right? After incarceration, blah, blah, all the way up. So here's my question. Do you agree with me?
Yes.
Okay, that's my question. Thank you, Mr.
No, I think one of the things, and to your point, Senator West, that we learned from the pandemic is there's so many opportunities for distant learning. That's one of the things that Massachusetts has done, and some of the other states have done, afforded those who are incarcerated the opportunity to work long distance or whatever over the internet and things of that nature. And so I think, we haven't really, outside of the goods that we produce, we haven't looked at other creative ways to keep people employed with the various emerging industries. And so it's just another opportunity to better prepare people with the skills so as they prepare to reintegrate back into our community.
Thank you very much. Thank you for the bill.
Thank you. Is that it?
All right, thank you, Senator Muse. Further questions from the committee? All right, seeing none, thank you,
Thank
Senator
you,
Hayes.
appreciate it.
Are these young people with you?
With that will conclude the hearing for Senate Bill 815. We'll now move on to Senator Mouts. We'll be here in a second with Senate Bill 751. Hold for a second.
I told my staff, I want, when I call the Attorney General, I want to see all the papers they've ever written on this issue. Yeah.
One on the paper, 2002. I'll make sure they give it to you.
Some opinions on the same whole issue.
Not unconstitutional.
Really, 4 says it's not a, but again, it was the same bill. But the earlier bills just wiped out.
All right, Senator Mouts, come on up. You're up. All right, Senator Mouts, you're up with Senate Bill 751.
Still having that hearing problem.
Senate Bill 751.
I apologize for keeping the committee waiting, Mr. Chair.
No
Mr.
worries.
Distinguished members, it's a great honor to present Senate Bill 751. 751 seeks to exempt Class K, also called K tags, from being required to carry motor vehicle insurance. I know that sounds scary. Don't be afraid. These vehicles are operated only on a farm or on a highway within a 25-mile radius from the farm. Since introducing Senate Bill 751, I have worked with State Highway Administration and the Maryland Insurance Administration on a compromise amendment. This amendment, along with a reprint of the bill, has been forwarded to the committee. I appreciate your consideration of this legislation. And to bring this into perspective, Delaware has different insurance requirements for their farm vehicles. So this was brought to my attention by some farmers who operate both in Delaware and Maryland. And so what this bill would do is require insurance for K-tags. It's just a different type of insurance rather than your standard auto insurance. The standards are incorporated with those amendments to make sure that these vehicles on the road are still insured, but they don't have to have the standard auto policy. They're on different homeowners policies and things like that. It works well in Delaware. There haven't been any problems, and it will help the farmers save a little money. And for the record, this has probably been one of the worst years for the farming industry since the early 80s. There are a lot of good farmers going out of business. Anything we can do to help them. And the bordering counties, when we have that Delaware, Maryland, it only makes sense if there's a good idea. Just because it's Delaware, it doesn't mean we shouldn't copy everything they do. But if it makes sense, then I don't see why to me, it's worth putting to you for your consideration and to urge for your favorable support.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you very much. That'll end the hearing for Senate Bill 751. We'll now move on to Senate Bill 912.
Thank you, Mr. Chair. Distinguished committee members, it's my honor to present Senate Bill 912. This legislation applies to vehicles which were registered as historic motor vehicles before July 1st, 2025. With the passing of legislation in 2025, which changed the date that defined historic motor vehicle, a number of individuals with historic tag vehicles no longer qualified for historic tags, yet these vehicles couldn't possibly pass inspection or wouldn't pass inspection without a considerable amount of expenditures to upgrade the vehicles. Senate Bill 912 would remedy that issue by creating an inspection exemption for any vehicle that was, number one, once a historically tagged vehicle prior to the law change July 1, 2025. This allows those vehicles to be registered, so they would still pay for registration until they once again qualified for the historic designation. An amendment was placed on the bill to identify the exemption for qualified historic motor vehicles from all inspections, not just emissions. So the way the bill originally was drafted, it says that they're exempted from emissions. This is to exempt them from all inspections. The amendment will be forwarded to the committee once it's received. So that amendment's in process. So this bill is much broader than the way it's drafted before you. And I appreciate your consideration. The intent of this is there are a number of individuals that had historic tags at one time. The law changed. Those vehicles were no longer historic. However, in order to register them, if they wanted to drive them on the road, they would have to get them inspected. And in order to get them inspected and to get them approved to modern standards, they'd have to spend thousands of dollars to upgrade the vehicles. So those owners approached me out of frustration because they didn't have the money to spend on their vehicles. They want to show off their vehicles, and they're still upset that they don't qualify for historic tags, but they'd be willing to pay for the registration to be able to use their vehicle, which in the meantime has had to sit in the garage. It's either going to sit there until enough time passes where they qualify for a historic tag, or they're going to sell the vehicle or something of that nature. So this is sort of a cleanup from that change in the definition of historic vehicle. I urge your favorable report.
All right. Questions from the committee? All right, seeing none, thank you very much, Senator Vance. We have, that'll end the hearing for Senate Bill 913. We'll now move, I'm sorry, for 912. We'll now move on to Senate Bill 913.
So I should have gone outside before I presented this bill. It's an honor, Mr. Chairman, distinguished committee members. We're talking about window tinting, and I've got those glasses where they change. If I came in, I have my tinted glasses on, I'd be perfect to present this legislation, but I've been inside. This Senate Bill 913 seeks to allow an out-of-state licensed physician to certify a patient's need as they apply for a medical exemption for tinting on motor vehicles. It also allows the physician to document the length of time the tinting permit will be necessary for medical reasons. Although there is currently a process for a patient to be authorized for permanent window tinting, in most instances, there's a 2-year limit on the tinting certification, after which time the patient must be recertified as qualified for medical exemption. I appreciate your consideration, and to qualify this legislation a little bit is that there are some constituents in rural parts of Maryland that have a difficult time to reach a doctor to get certified, and the intent of this legislation is to simplify that process and to ensure that once they're certified, they don't have to continually go back every 2 years and go through this process to be certified and filed. And that's the bureaucratic paperwork, that sort of thing. I'd urge your favorable report.
All right. Questions from the committee? Senator West.
Thank you, Mr. Chair, and thank you for presenting the bill. I guess my concern is I've seen enough television programs where you have some mafia-controlled doctor or something who's just on the payroll and will do whatever he's told to do. Isn't there a concern that some out-of-state doctor from someplace like Nevada all of a sudden is authorizing these window tints, and the window tints make it harder for the police department to do their job? And so criminal elements would use this same doctor to sign an unlimited number of authorizations for window tinting. Is that possible, or what does this bill do that would stop that?
Well, medical certification is medical certification. I tend to believe that medical certification is pretty legitimate if you get hurt and you go to a doctor. However, to the extent there are concerns and they can be rectified, I'd be happy to acquiesce to those just to help streamline the process. Window tinting is very common. Most vehicles now, when you get them, you know, the laws were changed so the passenger and the driver's side window can be tinted. But this is more designed just to try to get through the bureaucracy for those that live in areas where it's harder to get a doctor, it's harder to file the paperwork, and also to have the vehicle inspected, because it can only be inspected by Maryland State Police, that's inspected and approved. With regards to fraud and that sort of thing, there's always an element of fraud in the world. I think that, you know, that if there's a determination that an out-of-state doctor, like a fake ID factory, like a fake eye certification factory type thing, I imagine there has to be some kind of criminal law that could address something of that nature. Unfortunately, I don't have that handy. I'll do some research and get you that information.
Excellent. Thank you very much. All right. Further questions from the committee for Senator Mounts? All right. Thank you very much, Senator.
Mr. Chair, thank you. Great to see everyone.
Yeah,
Thank
likewise.
you.
Have a good one. All right. So with that, that'll end the hearing for Senate Bill 913. And for the audience members and the young folks here, it's usually not this calm in judicial proceedings. So, you know, so you're here on I mean, people just want to get outside, I think. All right. I think we're going to go to Senator Folden next with Senate Bill 678. All right, I got a
Pull up my panelists.
yes,
Thank you.
little dad joke while she comes up here. After stealing all the punctuation marks off of the judge's keyboard, I got a long sentence. Jail might mean one word to you, but it's a whole sentence for others. Okay, all right.
Oh, man.
All right, Senator Folden.
I'll laugh if it helps with moving this bill. If it helps with moving the bill, that's the funniest joke I've heard.
All right, here we go.
Thank you, Mr. Chair, esteemed colleagues of Judicial Proceedings. For the record, William Folden, Senator representing Legislative District 4. So what I'm going to do is I have an opportunity. I have an intern that has been working in my office and is from Towson, and Carrie Donahue, and she is going to introduce this very important bill regarding the genetic genealogical DNA analysis opportunities that we have here as a state. And I gave her the easiest bill I could think of to represent and present. So with that, I will turn it over to Carrie.
Hi, good afternoon, Chair, Vice Chair, and members of the committee. My name is Carrie Donahue, and I serve as a legislative assistant in the office of Senator William Folden, who represents District 4, Frederick County. And I'm here today to testify in support of Senate Bill 678. This bill addresses a technical gap in current law that is unintentionally leaving victims of cold cases and their families behind. Under current Maryland law, investigators must first attempt to upload DNA evidence into the Combined DNA Index System, also known as CODIS, before they can pursue forensic genetic genealogy. CODIS is an important tool, but it requires DNA samples to meet strict quality standards. Unfortunately, many DNA samples collected decades ago are degraded over time. It's important to note that these samples may still contain valuable genetic information that can be used to build a family tree through genealogy analysis, but they are often not perfect enough for the CODIS system to accept. As the law stands today, when a sample is rejected by CODIS, the investigation can effectively reach a dead end. Senate Bill 678 provides a different avenue for pursuit. It allows investigators to seek judicial authorization for a forensic genetic genealogy search in cases that are at least 15 years old, when DNA evidence is unsuitable for CODIS and all other investigative leads have been exhausted. Importantly, this bill does not give law enforcement a blank check. Investigators must still submit a sworn affidavit and obtain approval from a judge before using this method, ensuring appropriate oversight and accountability. Forensic genetic genealogy has already helped solve some of the most notorious cold cases in American history, including the identification of Joseph James DeAngelo, also known as the Golden State Killer, who murdered at least 13 people. This technology allows investigators to identify suspects who are not present in traditional DNA bases, offering new hope to families who have waited decades for answers. Senate Bill 678 simply ensures that a technical limitation within a database does not stand in the way of justice. Because of these reasons, I respectfully urge a favorable report on Senate Bill 678. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, honorable senators of the Judicial Proceedings Committee. My name is Sabrina Swan, Supervisor of Crime Scene Investigations for the Frederick Police Department. For the past 20 years, I've worked hundreds of criminal investigations for the Office of the Public Defender and the Frederick Police. But I'm here today to speak to you specifically about cold cases. A cold case is defined as an unsolved criminal investigation that remains open pending the discovery of new evidence or technological advances. Departments across Maryland may already possess the vital evidence needed to solve a cold case, but cannot due to the requirements and restrictions under this law with the STR entry into CODIS. Evidence can degrade while waiting for advancements in forensic testing, and over-testing samples can consume them to the point of no further analysis ability. Genealogy uses SNP analysis, which needs far less than STR. A rootless hair deposited by the perpetrator of a rape or a murder can be developed into mitochondrial DNA. It cannot develop STR due to the lack of root. Mitochondrial DNA is not eligible for entry into CODIS, but it can be used in genealogy, same as YSTR. The amendment before you would allow this evidence to be used. Families have asked why we're not trying genealogy, as it's being utilized to solve cases all over the nation. I have to explain to them why we're not authorized to do so under the law. It is absolutely heartbreaking to hear them express their frustrations that their loved one was murdered in the wrong state, knowing that we have ability and we have items, ways to solve a case, but not being authorized to do so. I am here to speak for those whose voices have been taken, for the victims of murder, rape, and felony sexual assault. Maryland investigators should have the ability to pursue every investigative route, not for us, but for the victims. They deserve it, their family deserves it, and the people of Maryland deserve it. Thank you for your time and consideration.
Good afternoon. I'm Sergeant Gregory McDonald from Prince George's County Police Department. I've been on the department for 35 years, and I've been working homicide for 28 years. Currently, it's not if, but when the state of Maryland will get a media-driven case similar to the 4 students that were murdered in Iowa, the Koberger defendant, that we will inherit one of those cases one of these days in the near future. And the limitations that's placed upon us would limit the way we investigate that case. And I can speak from that from 28 years of working homicides. Currently, if we have a case we're investigating and it's not in CODIS, we have to move on from that case and continue pursuing cases that are already CODIS eligible. That harms that family of that victim because we have to tell them we can't investigate that case. And trust me, citizens are very familiar with the limitations of DNA and the advancements in that science. That is something that we presented with daily when a family member calls our office. They ask about the DNA, do we have it, and what are we going to do with it if we do have it? And if it's not CODIS eligible, I have to tell them we can't do anything with it at the moment. Currently, if a case is old, the evidence degrades over time, as was spoken to previously. That may render it not CODIS eligible, but we can develop a SNP profile. That SNP profile can also use to exonerate individuals who may be under scrutiny in a homicide investigation. I can speak to that from personal experience. And I think that covers pretty much everything I need to state in this, and we appreciate your time and consideration on this bill.
Good afternoon, Mr. Chairman and members of the committee. I'm Robert Dean. I'm an assistant state's attorney in Prince George's County. I've been a prosecutor in Maryland for over 47 years. I am with the Cold Case Homicide Unit. I work with Sergeant McDonald. And since 2016, our focus has been on cold case homicides and sex assaults. In 2020, we were able to close a case, a murder case, that was 3 years old by utilizing forensic genetic genealogy. It was the first time it was used in the state. We were learning about it, and the defendant is convicted and serving his just sentence. In 2021, we received a grant from the federal government of over $500,000 to pursue forensic genetic genealogy in Prince George's County. Months after that, the Title 17, which is the law governing in the state of Maryland our use of forensic genetic genealogy, and we have been abiding by that law. We have utilized that law in our efforts, and we have solved a number of old cases by using forensic genetic genealogy. Some suspect samples are not sufficient to enter into CODIS. This very modest amendment to Title 17 will allow us to continue to pursue, because science has told us that we can utilize non-CODIS eligible forensic samples to help identify a killer or a rapist. And again, just about every other state in the union allows for that type of investigation. We would like to be able to make ourselves available to that particular technique. I would also just very quickly indicate that I do not understand why there would be a 15-year wait period to pursue this. To me, that does not advance the cause of justice. Thank you. I see my time is up.
Yeah. Anybody on the panel, you touched about it, sir, but why 15 years?
What?
Sabrina, can you?
I'm sorry, I couldn't hear you.
Yeah. Why 15 years? Could maybe answer.
I don't think it should really have a timeline that's that high, but I do know that some people might have opinions that they think that we should spend years and years and years and exhaust leads that don't even exist. 15 years would basically, there has to be something. We have to make a change. And if 15 years, we have to wait that long to get a family justice, then so be it. Honestly, in my opinion, I don't think we should have to wait that long either. But I also don't want to make it so tight that nobody gets justice.
If I may, Mr. Chair. Anybody know Sabrina, how many cases this would maybe open up?
Well, cold cases, they're never closed. In my department, all of our cases are still opened. We look at them when we can, and a lot of times when I have to assess a case for evidence and new technology, I often have to tell the investigators that are assigned that we can't do anything with what we have right now. So until the law changes, I'll just keep it on my desk and wait. We have evidence, but we can't test it any further without consuming it completely. So we might be at our last ditch effort, and some things might be, if we have an amendment to this law, we can attempt the last type of regular STR testing, but also gain a SNP profile at the same time. So if we don't have enough because it's too degraded, because the degradation could mean that you're missing some of the core loci and not meet the CODIS eligibility criteria. But if you keep testing, you might consume the entire thing and genealogy won't even be an option. So that's why the cases are constantly open and looked at. And evidentiary-wise, the evidence just keeps aging.
Final. So obviously this could be used to prosecute people, but could this be used to exonerate?
Yes. Yeah, well, with my time at the Office of the Public Defender, one of the biggest things I looked for was, is everything that is being portrayed or put forward actually pointing to the defendant that's being charged, or are there alternate possibilities? And you could have a situation where you have a lot of evidence, and it could be circumstantial evidence that points to a particular offender, but maybe you have a hair or you have a partial YSTR or mitochondrial profile, but if you're not allowed to use that because you can't enter it into CODIS and it's not authorized under the law, you could be prosecuting the wrong person.
Okay, thank you. Thank you, Mr. Chair.
First of all, I just want to congratulate you on presenting the bill. You did a great job. And then second, and this is for whomever, what does suitable for direct comparison mean?
Well, as a prosecutor, we want to know that the suspect sample, the offender who has left a sample at the crime scene, that as a matter of fact, it can be utilized in a comparison with a known sample to see if it matches. That's all that is meant by suitable for comparison. And that's done at the crime lab.
So, if I may, so who makes the determination that it's suitable for direct comparison?
We rely, and I think the sergeant, my partner in crime here, we rely on the people at the crime lab. And if they think it's suitable, we think it's suitable.
In cases where a DNA profile is developed, we'll either get a result that says that it's suitable for entry into CODIS and that it's been entered, or that a profile has been developed that's suitable for direct comparison, but is not eligible for CODIS. When they say it's not suitable for CODIS, but available, you can do direct comparison, that basically means we have to go around to each individual person and collect their DNA and do direct. But if you don't have enough probable cause to get a warrant to get their known standard, then you could have people that are deceased, you could have a serial killer, you could have all of these circumstances where you're basically just going through your entire population trying to get a known standard to directly compare. Like with males, YSTR, that's the male lineage, that Y line. It is distinct for that exact male line. And through the investigative, information and concert, you can go through and say, this person was deceased at the time, this person was deployed in overseas, this person wasn't even born yet. This is the only person of this YSTR line that was present at the time. And so in court cases, that's what they're looking for, but YSTR is also not eligible for entry into CODIS.
Got it. Thank you. Thank you, Mr. Chair.
Chair, Mr. Dean, maybe I could talk to you for a moment?
Yes, sir.
So I've read enough books, procedural policing books, and watched enough on television. And there's never a conversation in either the novels or the TV programs about, well, this is DNA which we can't test. And I guess that's why you're saying Maryland stands out from the other states. Because in the other states where these TV programs are made or the books are written, they can test any DNA they find, correct?
We can test DNA. It's just that under Title 17, we have what I'll say are stricter guidelines than just about every other state in the union. So we can, but under the strictures of Title 17. And I don't know if that sufficiently answers your question, but we don't feel hamstrung, let's put it like that, except when it comes to those cases that are not CODIS eligible. And that's what this amendment tries to fix.
Right. I guess that's what I was, in my inartful way, trying to suggest, that in other states, whatever the DNA is, it can be tested. But in Maryland, because it's not CODIS eligible, can't be tested.
That's my understanding, and I've worked with a number of other states in this, so yes.
So let's talk about the other half of this equation, and that's whether it can be introduced into evidence. Am I correct in surmising that non-CODIS eligible DNA cannot currently be introduced into evidence, and even if this bill is passed, would not necessarily be admissible into evidence, because this bill does not affect whether or not that DNA can be introduced into evidence?
That's incorrect.
Yeah, the whole forensic genetic genealogy process does not get into evidence. It's the match between the suspect who is identified
Right.
through the process
So you-
that comes into evidence.
So what you're doing, if this bill passes, is you're able to screen a whole lot of possible suspects and exclude all but one because that one has DNA. And then you can focus your attention on that one and try to develop admissible evidence which would prove that that one individual committed the crime. Am I correct in that?
That sounds correct.
Yes.
Okay, thank you.
I realize that I'm not a biologist, so don't think that I'm a biologist. When we talk about STR, that is a full genetic profile. And by full, I don't mean as in full, as in it's the entire genetic profile of the individual. The loci that are developed, there are core loci that are required for entry into the state and national CODIS. But you could have a profile that is missing one of those core loci. It's enough that even if the CODIS eligibility requirements were a little less, would be eligible for CODIS. Mitochondrial DNA and YSTR, they are used in court all the time, but that's often when they already know a suspect, they're able to directly figure out who they are, get their known standard, and directly compare. But in a case, some of my cold cases, it's a complete unknown of who the suspect is. All known suspects to the case have been ruled out. So seeking serial killers, seeking random people that have been in the area and confessing, we've spent, almost 40 years doing this, where if we could use that sample and do genetic genealogy, we might actually be able to give this family justice before the parents pass, the rest of the siblings. Okay. It is used in court already, but we're not allowed to actually use it for genealogy.
Great, thank you so much.
Excellent. Further questions from the committee? All right, thank you all very much.
Thank you, sir.
Thank you. With that, that'll conclude the hearing for Senate Bill 678. And now we'll move on to Senator James with Senate Bill 743.
Thank you, Mr. Chairman. May I bring the panel up? I think. Thank you. I'm missing. Give us 10 seconds.
Talking about cold cases, my best friend's wife is an undertaker. They have 2 cars, his and hers. All right, I'm trying to tap dance, waste some time, all right. Here's what I told my daughter last night. How do you get a Kleenex to dance? Put a little boogie in it. All right. These guys are gonna keep coming if we don't get a senator up here. All right, here we go. I'm gonna subject you to more dad jokes if you go ahead.
Well, I'm sorry. One of my witnesses may not be here, but
Do you want to wait? Senator Kagan is on her way.
Yeah, I'm sorry. I don't want to. I said I was ready, but I didn't realize one of my witnesses
No worries.
wasn't here.
Senator Kagan's
All right.
will be here very
Let me
shortly.
reach out to my staff and say.
No worries. Take your time, and I will go.
They were coming representing Western Maryland, so I don't want to short circuit.
Okay, no worries. Take your time. This is an old one, but when you die, what part of you dies last?
Yes.
Yeah. Your eyes. They dilate. All right. Man, these are gonna get worse. All right.
He's on his way.
Okay, take your time. Take your time. Emily, do you want to come on? Oh, sure. We can go now. members of the committee, Senator Smith here to present Senate Bill 693. So just to rehash some of the history, it was interesting in doing some research for the bill. We found that the history of the Child Victims Act, some of our efforts to allow survivors to seek civil justice, access to civil justice, date back to 1994. And then in 2003 was actually the first time that we established a 7-year statute of limitations for civil claims arising out of child sexual abuse. Fast forward to 2017, some of you may remember, we did some reform there, creating a farther look back. And then finally to 2023, where we passed the Child Victims Act, allowing a full look back for survivors of child sex abuse, and then also raising the caps for the local Tort Claims Act and the State Tort Claims Act from $400,000 per incident and occurrence to $890 for claims against the government. And for private entities, we raised that cap to 1.5, we capped it actually at $1.5 million per claim or occurrence. So that is where we left in 2023. That bill then became law in October 1st of 2023. And in the wake of us creating this look back, there were, as anticipated, a number of claims that were generated on both against the government and against the private sector. We came back the subsequent session and passed a piece of legislation that brought the caps back down for claims against the government. They were back down to 400 per incident or occurrence, and it brought those caps back down to $700. It curtailed those caps from 1.5 million to $700,000 for private entities. And again, that language was from the Local Tort Claims Act per incident or occurrence. To my, and I think to a number of folks that we were going through this process, and Emily, help me if I'm wrong, but there really wasn't clear definition of what incident or occurrence was. Even though that statute had been on the books for 40 years at the time, it just hadn't, there was no common law interpretation there was no judicial interpretation as to what that meant, which was shocking to me. But nonetheless, the piece of legislation that we passed in 2014 developed the definition, brought down those caps, and then also said, it said that those new caps would apply for any claims filed after June 1st of 2025. And so there was, as anticipated, a number of folks that filed because they wanted to file under the higher caps. And so they filed before that June 1st, 2025. So that was obviously a legislative attempt to shield the state and also private entities from excessive liability, which from this flood of cases, because there were so many cases out there. I understood that, and I think that was the policy objective, especially that came amidst a significant budget shortfall. So all this confluence of events came and happened, and that's why we had that. But also, what that piece of legislation did in 2024 is that it actually did something that we've never done before. It said that it capped attorneys' fees to 20% of a settlement or 25% of a judgment if it went to trial. And at the time, I begrudgingly went along with it because I understood where we were as a state and the precarious nature of our finances, and I understood that. But I always felt that this was a piece of the legislation that would actually serve to greatly hurt or to curtail access to justice for survivors, because especially for revived claims, which, by the way, these new caps and these fees, rather, apply to revived claims and also to new claims. But understanding a large amount of resources that attorneys have to expend to get these cases off the ground, to get the research, to get the information, especially for the revived cases that have happened a long time ago, it's costly. It's a costly endeavor. And when attorneys cannot be compensated for that time and expertise that they spend developing these cases for these survivors, they won't take the cases. They can't take the cases. They can't afford to take the cases. And what happens is a lot of meritorious cases are left unaddressed because they don't have access to counsel, because the counsel can't afford to do it and make that upfront investment. And so what this bill does is it removes those caps on those fees. And I'll say, because and Emily will, I think, expound upon this, I am unaware, we don't put caps on the defense side, by the way, for their fees. And I'm unaware of any other place where we put these types of caps on attorneys' fees. And I think it's to the detriment of survivors, many of whom have had their cases unaddressed because the attorney simply can't take their case. I also say that there's a lot of talk about extreme fees, and the rules of professional conduct govern the reasonableness of a fee that can be assessed in that attorney-client relationship. And so there are protections for fees and for reasonable fees, and that has worked throughout the entirety of our legal history here in Maryland. It was only in 2024 that we put this cap in place. And so for those reasons, for the committee, I asked for this committee for a favorable report to allow for the survivors for whom we intended the 2023 law to avail themselves of access to justice and allow the attorneys to do this, have an adversarial day in court, suss out the merits of their case, and hopefully justice will be done. So with that, I'll ask for a favorable report. I'll turn it over to Emily, and then we'll take questions. Thanks.
Hello again, Emily Malarkey on behalf of the Maryland Association for Justice. I think Senator Smith did a great job summing it up. I just have a few points to emphasize and add. One is that Maryland has long embraced the principle that private parties have the freedom to contract. And when you hire a lawyer and you enter into an agreement as to what to pay that lawyer, that is a contract. And as the senator said, that has worked just fine up through now. There's been no case or example other than cases against the government under which attorneys' fees for plaintiffs' lawyers have ever been limited or capped. And as the senator said, defense lawyers' fees have never been capped. CVA cases, all catastrophic injury cases, are expensive and difficult and take a really long time to get to trial. But CVA cases are no exception to that rule. We're talking about cases with evidence that is from decades ago. We need to retain attorneys on the issue, experts on the issue of liability, which is proving that whoever it is we're suing knew or should have known that a person was a child abuser and failed to act to protect them. That involves hiring experts, and experts on the issue of damages, which is what is the harm and what psychological impact did it have on the survivor. Those experts cost a lot of money. We're seeing tons of legal motions in court challenging these cases on various other defenses like charitable immunity, the doctrine of latches, sovereign immunity, you name it. They're taking a really long time to get through the civil justice system. And those that have resolved, because few of them have, are not resolving for astronomical amounts. The effect of any cap on recovery, like the one that was imposed last year, lowered to $700,000 and $400,000, is that it creates a ceiling on what the person can recover, which impacts settlement values. So when we take a case, we know what the likely settlement value of the case is based on the cap. We can calculate what we may be paid. It's not enough to justify taking the case in the first place. When the law makes a case impossible to bring, a promise that you made to these survivors is theoretical in nature only. So we ask for a favorable report on this bill.
Questions from the committee? All right. Seeing none, Senate Bill, which one is this? 693, that's the end of the hearing, 693. Thank you all. Cited in opposition? Okay. Are they virtual or are they? No, it's Jordan. She's on. Oh, she's on. Lisa Jordan's on. Okay. Oh, jeez. Here we go. Hey. Your favorite with amendments, right? We just wrapped up.
We just wrapped
Yeah,
up.
sorry.
Sorry about that.
Throw you in right away.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in favor of Senate Bill 693 with amendments. Thank you for the aerobic activity on such a lovely day. You know, I actually don't care if you limit caps, attorney's fees on CVA cases. I will tell you that in the past couple of days, I've talked to 2 survivors. One at the Women of Color Network conference on Friday came up to me and said, you know, I was sexually abused and I can't get an attorney to take my case. All I want to know is, was I abused at an institution? You know, how much money does the perpetrator have? And she needs help. You know, she needs counseling. She needs access to some kind of legal rights. And then the other woman, she emailed us at the Sexual Assault Legal Institute, and she gave me a very detailed account of her case. And, you know, although I don't do tort work, I've been doing sexual assault work for a long time. She's got a really strong case. And she said, you know, I can't find anybody to take my case. They keep saying they have too many CVA cases. So I question this idea that you need to remove the cap in order to have people take these cases. It sounds like they're pretty filled up in the private bar. But what you're missing is you're missing all of the people who don't want to go to court, or the witnesses are dead, or the evidence is weak. And so the amendments that the Maryland Coalition Against Sexual Assault has submitted, you've seen before, Senator West, you presented them last year when they were amending this bill, and it would create a fund. It would say, let's put a surcharge on attorneys' fees that these attorneys are making in these cases. Let's put it in a state-controlled fund, and let's use it for prevention. Let's use it for services. I will tell you, in Washington, they are going to get rid of our prevention money. Maybe I'm wrong. I hope I'm wrong. But the chances are we're not going to have that sort of funding. The chances are we're going to have less and less money for services. We need to start thinking about that now. And we also need to look at the needs of these survivors. They were sexually abused too. The private bar is not tripping over itself to help those survivors. They are tripping over themselves to make money. They got every right to do that. I appreciate what they do. I have no bones about that. What I'm saying is that you are leaving out a huge swath of survivors, and they deserve our help also. And so for those reasons, the Maryland Coalition Against Sexual Assault asked for these amendments on Senate Bill 693.
Questions from the committee? From here.
Hearing none, that'll conclude the bill.
I had a question. Thank you, thank you, Mr. Chairman. Just because you brought that up, I don't know if you all have communicated about these amendments, but has this idea that you're putting forth, which is quite different than the bill, to be honest with you, right? Has this been done anywhere, sort of a surcharge and then a fund? And I'm sorry, did you already say that?
No, not at all. That's a wonderful question. And yes, I met with the chair who was very, very receptive and I think open. And I hope that it's just the pressures of the time of session that means that we don't have more information about that. I know he wanted to socialize the idea. But Maryland already does this in workers' comp cases. You know, you have that uninsured employer fund. So every time there's, I
understand
that sort of case. So it's, so it's a little different. But it I mean, and so there are a couple of places where we have surcharges. So it's not some sort of radical new idea.
No, I just didn't know if in this particular space.
Yeah, not that I know of, but this is such an obvious place to do it. And other states have statutory caps on attorneys' fees. Right. So we're already out of line with that.
And then, Mr. Chairman, just because, again, I don't mean to use Lisa, but Ms. Jordan, but if it sounds like she's almost saying, look, there was a lot of cases that came rushing in, right? And that perhaps we don't have as many cases out there that aren't being taken up and/or there are other needs of some of these. The people that didn't rush to court or haven't done it for a couple of years, they're not particularly interested in going the distance for a case, but they do want help. They do want help. They don't need to relitigate this. So just hearing what she said, does that make you think a little differently about whether the cap is something that needs to be lifted, or if that's really not what's impeding helping survivors, but more that we don't have enough services? So I don't mean to put you on the
No,
spot,
no, no.
but it's an interesting conversation to have, really.
It is. To which cap do you refer? The one on attorney's fees? Or
Yeah,
the
attorney's fees, what you're dealing with.
No, I think I'm very much committed to removing these caps on attorney's fees. I do think it does curtail access.
You do?
And Emily can speak to the numbers specifically, but I think you saw a surge because we set that deadline for access to the higher caps of recovery before that June
I see what you're
1st,
saying.
2025 effective date, and that's why there was a surge of cases.
Yeah, that's
Okay.
exactly right. The June 1st deadline
Right.
meant that everybody needed to put their case into court by that deadline, or
Right.
they were going to lose out on the higher cap. So the attorneys that are handling these cases right now,
That was a higher cap on the
on recovery.
recovery, not attorney's
So
fees.
we put all of our cases into court before June 1st, and now they're all being litigated all at one time.
That's right.
So a lot of attorneys can't take new cases now for two reasons. Number one, we're busy with the cases that we have.
Right.
Number two, this attorney's fee cap with a lower cap on recovery.
But you're saying the two together.
The two
is really-
together compound the problem. When you have a $400,000 hard cap on what,
Right.
the only way you're ever going to get that 400 or that 700 or that 1.5, the only way is if you go to court and you try that case and you get it from a jury. If any defendant is going to settle that case, they're going to settle it for a
Yeah.
lot less, which
All right, that's very helpful, thank you.
Just, and
That felt good.
I mean, to Ms. Jordan's point too, I mean, one thing that I thought we missed an opportunity to do was to create a fund. And I think we've got to be able to figure out a way to make sure that there's a sustainable way
Yeah.
To support survivors with ancillary services. So I think that's a missing link. I thought we missed an opportunity in 2023, and maybe we have one here so that we can talk about. So,
All right, thank you.
Senator Fulton.
Any other witnesses, seeing none?
Seeing none. You just took the chair. Thank you. All right, we are joined by the distinguished Vice Chair. Senator Kagan is here to present Senate Bill 950. Our apologies for the delay.
All good.
Welcome back.
Glad to be here. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. Mr. Chair, colleagues, my other bill that I brought to your wonderful committee, you passed out unanimously, so maybe we could just pass this one out unanimously without the hearing, because that'll go better. In 2018, the state of Maryland passed a ban on conversion therapy. And to be clear, conversion therapy is an alleged health care option, which is not that. And it tells members of the LGBTQ community that they are wrong, that they are bad, that they are broken, and that they need fixing. And so they are sent away for counseling or a camp where they are treated often horrifically with mental and/or physical abuse. Oftentimes, it takes a while for people to acknowledge the trauma, to recuperate, and to be ready to speak up and to share their journey, to ask for compensation. And we all remember about child sexual abuse survivors, and we created a path for them to be made whole. And obviously, in those cases and in these cases, money doesn't fix things, but it sure does help acknowledge that something bad was done to you. So Senate Bill 950, there is similar to 4 other states and the District of Columbia. There's no fiscal note. We are dealing right now in these tight fiscal times with how do we do the payout for child sexual abuse survivors. In this bill, there is a fund created, and the fiscal note you will see has no fiscal impact. There is a fee that would be assessed to providers in increased insurance costs. And that fee would be aggregated and set aside so that someone who has been damaged, who brings a suit, would be able to receive compensation. There are two different levels of time frame, because right now our 2018 sunset, or the deadline, is way too short. And again, it takes time sometimes for people to be willing to acknowledge and then to step forward. So there's an under 18 and then an over 18 piece of that. So there's an acknowledgement that a younger person may take longer to recuperate. An older person, we still should give them until they turn 40 from their last therapy session. And for those who may be listening and can't see me, I'm putting ferocious air quotes around the word therapy because it really is abuse. So with that, I've got experts with me, and we tried to keep it short out of respect for the committee and the fact that you guys are always in here till midnight and stuff. So Tanner Mobley with the Trevor Project, and then we also have Shannon Minter, who's virtual, and I defer to them, but happy to take questions after their testimony. Thank you all. You can come on. Yeah, you can stay. No.
Okay.
Sorry.
No worries. Good afternoon, Chair Smith, members of the committee. My name is Tanner Mobley. I'm based in Baltimore, and I'm testifying in support of SB 950 on behalf of the Trevor Project, the leading suicide prevention organization for LGBTQ+ young people. We provide 24/7 crisis intervention services to young people across the country. And right here in Maryland, our research shows that nearly 40% of LGBTQ young people attempted or considered suicide in the past year. To help end this crisis, Trevor is dedicated to ending the end of practices commonly referred to as conversion therapy. Practices practices condemned by every reputable medical and mental health association as harmful, ineffective, and built on theories that have been debunked for decades. At Trevor, we don't just oppose conversion therapy on principle, we see its consequences every day in our crisis work. Our 2024 national survey found that nearly 1 in 7 LGBTQ youth were subjected or threatened with conversion therapy, and those youth were twice as likely to have a suicide attempt in the past year. The harm is ongoing, and so are the costs. A peer-reviewed study in an American Medical Association journal found that practitioners have extracted millions from vulnerable families to pay for these practices, to the tune of $650 million in direct costs annually. This bill ensures survivors have the opportunity to hold these practitioners accountable. Survivors deserve justice, but seeking justice requires time to heal enough to come forward, time to process what's happened to them. And the current statute of limitations doesn't account for the severity or the complexity of that harm. The Trevor Project strongly supports SB 950. When a young person calls our crisis line in the middle of the night in their darkest moments, we answer. And you have the opportunity to answer today as well by holding conversion therapists accountable. So thank you.
Excellent. Thank you very much. We're going to hear from Shannon Minter, and then we'll open it up to this panel for questions from the committee.
Thank you very much, Chair and members of the committee. My name is Shannon Minter. I'm the legal director of the National Center for LGBTQ Rights, and I've litigated conversion therapy cases across the country for over 30 years now. The heart of this bill does an extremely important thing. It does not create a new cause of action. It ensures that survivors who already have a right to sue have enough time to exercise that right. Every major medical and mental health organization has concluded that so-called conversion therapy doesn't work, and survivors are left to internalize that failure as a personal defect. They blame themselves for years before recognizing that what was done to them was harmful and wrong. The psychological injuries that result, depression, post-traumatic stress, very high rates of suicidality, are serious and they last a long time. So under current Maryland law, the limitations period for conversion therapy survivors may expire before they even finish high school, like years before most survivors are capable of recognizing the source of their harm. This bill ensures that malpractice claims against licensed mental health practitioners are governed by a uniform extended limitations period. For minor survivors, it ensures that there's no arbitrary deadline that would bar the courthouse door to them. That's consistent with what Maryland has already done for another group of young people under the Child Victims Act of 2023, which the Maryland Supreme Court upheld just last year. So this is very well precedented. Maryland law generally does not permit limitations periods to run against plaintiffs who could not reasonably have recognized their injury. This bill applies that principle in an area where it's really urgently needed. So I urge the committee to report it favorably. Thank you.
Excellent. Thank you very much, Shannon. All right, well, we do have Jeremy Browning is signed up in favor. Is Jeremy Browning here? Yes. Excellent. Come on up and you can testify, and then we'll finish up. We'll open it up for questions for the proponents.
So good afternoon, Chair, Vice Chair, members of the committee. My name is Jeremy Browning. I use he, him pronouns, and I'm here on behalf of the Maryland Commission on LGBTQI+ Affairs. And thank you, Senator Kagan, for bringing this bill forward. The commission was established to assess the challenges facing LGBTQI+ communities and establish recommendations and best practices for inclusion. Every major medical and mental health organization has determined that the efforts to change a person's sexual orientation or gender identity are harmful and ineffective. The commission's statewide community needs assessment surveyed over 1,200 queer and trans Marylanders from all 24 jurisdictions, and the preliminary findings report reinforces the urgency of this issue. Over 22% of respondents reported seriously considering suicide in the past 12 months, and more than 61% reported lifetime suicidal ideation. In addition, almost 50% reported sometimes or always avoiding medical care due to anticipated discrimination. These findings demonstrate that many queer and trans Marylanders are already navigating significant mental health stressors and barriers to affirming care. Practices that seek to change a person's identity compound shame, undermine trust in providers, and deepen the very disparities the state is working to reduce. This bill takes a comprehensive and thoughtful approach and establishes a clear path and the time needed for survivors to seek justice. And for those reasons, we urge a favorable report. Thank you.
All right, thank you very much. All right, we're going to start off with Senator Muse. Before Muse poses his question, if you're our Senate page, you're welcome to come up to the side here and see if you'd like to. You're always welcome to come up here. We'll even let the House pages come up too. It's all good. All right, Senator Muse, go ahead.
Thank you very much, Mr. Chairman, and thank you all very much for talking and letting us know, giving us the information. The first question, you mentioned a number. I think you said 650 million, and that's statewide or nationwide?
Yeah, that study is referencing $650 million in direct costs annually, so actually paying for the conversion therapy practices themselves. And then we know the indirect costs of treating mental health issues, depression, anxiety, substance abuse, sexual disorders that come from conversion therapy is actually in the billions.
And those numbers represent nationwide?
Nationwide.
Okay,
yeah.
Thank you. And pardon my ignorance on this. What does conversion therapy consist of? Do they try to attack the mental, the emotional? Just tell me if you know what would go on in some of those sessions.
So in this context, we're talking specifically about licensed practitioners. So you're going to see a range of tactics used, but most of them attempt to get a person to associate their identity with shame, with repulsion. Our opposition will call it talk therapy, but it's an attempt to get a person to feel shame around their identity. So I've heard, and I'm happy to share some stories with you all via email, but anywhere from making a patient smell dog feces every time they have thoughts about someone of the same sex to just recounting their sexual fantasies to a therapist and working in aversion techniques to try to get them to associate that with something negative. They're very creative with the tactics, and I could send you a whole list, yeah.
Thank you both, and thank you, Senator. Thank you.
Thank you, Mr. Chair. Thank you, Vice Chair Kagan, for bringing this bill. I'm confused. So this body banned the use of conversion therapy, and yet there are still a lot of people who are doing it in the state of Maryland? What remedies, what's being done about that, and what remedies do these youth have?
Yeah, so our the Trevor Project's It's Still Happening report, this is an undercount, but has found at least 1,300 practitioners of conversion therapy across the nation, and that includes many states that have bans in place. Unfortunately, that is due to a lot of the similar issues to reporting sexual assault. There's just a lot of barriers to actually reporting these practices, and this bill would make that easier to actually enforce against these folks.
Senator Love, the other thing that's significant about this bill is it enhances the time frame. So it's too soon after an assault, after a traumatic, shameful, depressing, horrifying experience. Sometimes it takes several years, maybe of legit therapy, to be able to come out and speak about it and be willing to bring a court case. So this extends the timeline for minors and for adults so that there's more time for them to step up and seek compensation.
Got it. Thank you.
And to that point, like what the bill passed, I believe, in 2018. So realistically, there are survivors who are unable to file claims just given the time in which the bill passed and the current statute of limitations.
Thank you.
So these, and again, these are young people below the age of 18, because I'm assuming that because they are being, lack of another term, they are forced into these programs based on what I've heard, right? They're forced. So these are mostly underage. Yeah.
I'll start, but I can let any of my wonderful witnesses add on. This bill would create two lanes. One is for people who still are minors, who are under 18, and they might have been subjected, forced, into this situation younger, and they're going to be able to bring a claim up until the age of 40. For those who are older than 18, they would be allowed to bring a claim for 10 years after their last session.
Okay, and I'm assuming that again, that when they bring these claims, that they're bringing the claim from the time that they were young people forced into this by parents or whomever. Is that right?
So I believe that's right. Shannon, do you want to add on to that about people over 18 who also may be lured into this kind of abusive care?
The bill would extend statute of limitations very broadly for minors, people who are subject to it as minors, and for a significant time for people who are subjected to it as adults. But, your question, yes, sometimes parents are just as much the victims as the young people here. That is really part of the harm that we're so concerned about, is these therapists target people who, of course, love their children. They're concerned. They're worried that they won't have a happy life if they grow up to be gay or transgender. They're very vulnerable to being told, hey, if you put your child in therapy, I will prevent them from being gay or transgender. They're not really gay or transgender. I'll make sure they don't grow up to be gay or transgender. So, and then what happens almost always, these therapists have the view that the reason a young person would identify as gay or transgender is that there's something wrong, deficient about their parenting. And so they, at the very time that these young people most need the support and trust and open communication with their parents, they're being told by a therapist, your parents are the source of your problem. We see over and over again, it drives a wedge between these young people and their families. It's so harmful to these young people. These families are fractured, they're really harmed, they're paying money for therapy that doesn't work and that is causing their child harm, that these parents would never put their young person into these therapies if they knew the truth, that there's just no evidence that there's any therapeutic technique that can change a person's sexual orientation or transgender status. And that's, why Maryland's already told therapists you can't do this to young people, but we know it still happens. It still happens. And there is already a mechanism. If you're subjected to this, your child is, or you are, you can bring a malpractice claim, and it is malpractice. It absolutely is. But right now, the statute of limitations is so short that most of the young people who come to us after going through this, or even the families who come to us and they're like, we want to do something about this, it's too late. I mean, it's a very short window of time. And this just extends that, recognizing that this type of harm really usually takes people a while to connect the dots and to recognize that what happened to me was not my fault. I didn't fail. This therapy doesn't work. And I was being made promises that are just untrue.
Thank you for the information, and again, thank you for bringing the bill. Very informative, and I thank you for that. Mr. Chair.
Thank you, Mr. Chair. So, I'm kind of at a loss here, because as I'm reading through this bill, and Senator Kagan.
I know, I can't see you.
I just want, I know, you were hiding on the other side.
Hi.
It's within 20 years after the plaintiff last conversion therapy was as an adult. So I thought you may have said 10, but I think it's 20, is what it says in the bill. But, so here's my Mr. Mentor, thank you for your words. So this is where I'm struggling with this, because for years, I'm one of the people that's been advocating for the involvement of parents in children's lives and the importance of that, not fracturing that bond and having that continued dialogue. And for years, we've been getting shut down by the school boards who have facilitated these identifying early types of, I don't even know what you want to call it, but behavior by their child that would indicate that potentially they could use some additional dialogue with their family and others. And so the school boards are still taking a position that they don't notify families when a child wants to identify as a different gender or name. But this bill seems to now, and correct me if I'm wrong, and I'm going to apologize if I'm totally misunderstanding what this bill's about. This bill is now looking to target those therapists that have, I mean, for all intents and purposes, been purposeful with their intent to enable or push these very vulnerable people in a direction that would cause them more harm psychologically as well as potentially physically. Am I missing that? Am I just way off, or I just want to make sure that I'm putting this all together, because this is something that seems that there's not a great disconnect from the issues and struggles we continue to have with the school boards for parental rights, but then we have this bill coming forward, which would then open up. And you can speak to it, sir.
Sure.
It looks like you're pretty eager to.
Yep. I'm going to start, Senator Fulton,
Sure,
and I'm going
sure,
to pass it to
sure,
Tanner
thank
if I
you.
could. So thank you for the question. Let me just be clear, nothing in this bill affects school boards?
No, I
Nothing
understand
affects, okay. There's no mandate on parents. There's no mandates on our local boards, local educational institutions. I can't recall, I don't know whether you were here yet, Senator, but we have a colleague, a wonderful colleague, whose daughter served in the House. And when we were debating and passing this bill, she gave a really powerful floor speech and talked about how her parents put her in one of these conversion therapy camps. And it is available publicly online, so I'm not telling a family secret. But her trauma affected her whole life and caused a rift in the family. And that's the way it happens. So this is not creating a new problem. This is a problem that has resulted because of a parent's misguided hope that they might be able to do something to help their child, but it does absolutely the opposite. Tanner, you can speak to it better than I can.
I think we have a lot of the same goals here. We both want kids to be safe, healthy, and be able to live full lives. So under current, all code of ethics, under every mental health and medical profession, they cannot, a therapist cannot come into a session with a predetermined outcome or basically coming into it with an agenda. So whether that is pushing someone to be straight or pushing someone to be transgender, a therapist is not allowed to do that underneath their code of ethics. And would be considered a violation of that regardless.
So I guess that's kind of where I'm getting confused here, is because we've had discussions where, and this body has taken action on keeping some of these treatments, and not necessarily like how this is worded, but whether it's psychological evaluations or others, secret from the parents because of, I'm guessing, the perceived that they would end up in a conversion therapy. I guess, am I wrong? You're talking about both sides of this, or are we only talking about the therapist that would be looking to, like, are we holding just the parents accountable here?
Oh, we are.
Or we're holding the therapist if they were to lead them in a manner that would create self-harm or, you know, or body mutilation because they're kind of encouraging, because we're just in such a really terrible time in our society where we're having a lot of discussions about some of these things and the limitations of parents and why we're not allowing parents to know about certain things, but then we're providing services because the therapists or the school counselors know best for the children. So we have and you can chime in, Senator.
Thank you.
I mean, I'm just trying to.
Thank you, Senator Folden.
Walk
First
through
off,
this.
thank you for flagging that I had a typo in my notes, and you were right for 20 years, so I apologize, and thank you for catching that. Second, there's nothing about this bill that punishes parents in any way. Presumably, they were well-intentioned and wanting the best for their child, as I think Tanner indicated. We're talking not about talk therapy necessarily. We're talking about beatings. Beatings, physical abuse, mental abuse, deprivation of food and water and liberty and being bound and being, I mean, I watched some videos, and I don't recommend that you all watch the videos because it's really horrific, and they cause lifelong damages, and they don't reach the solution that a parent or guardian may be hoping for, or the person themselves. And as was mentioned, survivors of this horrific abuse are more than twice as likely to attempt suicide and 2.5 times as likely to attempt it multiple times. And at some point, they may succeed. Yeah. And it's as a result of surviving this abuse. So I really hope that we can see right by them at no fiscal cost to the state, but it will also, not only will it help survivors of abuse, but it will be a serious disinclination for anyone else to violate our laws to make sure that no one else is doing this to other people in Maryland.
I appreciate your answers. I appreciate giving some clarity. Thank you.
Thank you, Senator.
Excellent. Thank you very much, Senator. Thank you all for. Senator McKay has a question.
Thank you, Mr. Chairman. Tanner, can I ask you a question, please? So as a follow-up to Senator Love's question, I think you said there was like 1,300 of these therapists throughout the United States. How many are in Maryland?
I don't have that data handy at this moment, but I can send it to you.
Yeah, I think that's really relevant. I mean, I'm not saying this is not a kind way, but it sounds like we're trying to chase a solution and we're going to create a problem. And the data needs to show that this is happening in Maryland. I tend to believe what we did in 2018, for lack of better words, said to the legislature, said to the state of Maryland, we are not going to have this. And the senator had mentioned about these horrific tying up and all this kind of stuff. I've never heard of that. It's horrible. But the other question that I would have, so I'd love to get that information from you. But second of all, so when it defines conversion therapy in the bill, my question is, how does a therapist who's having the discussion of sexual orientation or gender identity, how does that therapist know that they're not they're crossing over into the line where the bill defines as conversion therapy? I mean, it'd be one thing if I had a shingle out and I was selling these services, this is conversion therapy, which is wrong. But how do we talk about it, and how does that therapist now fall into that avenue?
Absolutely. And like I said, I will follow up on the Maryland data. I can confirm there are licensed practitioners still using conversion therapy in the state, and I'll get those exact numbers to you. In terms of your second question, so therapists, their role is to help a person explore their feelings and what's going on. So for example, I think to your question, if a young person comes to a therapist and says, I think I might be transgender, I don't want to be, I'm worried how this will impact my experience at school and with my family, they're allowed to talk about that, and the therapist cannot jump in and say, like, you're absolutely right, and I can help you not be transgender, or vice versa. Like, if essentially the person just cannot come into it with a predetermined outcome and an agenda. They cannot say, I can promise that I will make you X, Y, and Z, and we'll do that using X, Y, and Z. Their role as a therapist is to ask them questions, help them explore their identity, ask them like how various things makes them feel, and how they're if they're worried about coming out to their parents, like how that may manifest, things like that. They just cannot come in and say, I have the solution for you that will make you straight, or I will make you transgender. Either direction, they have to be neutral.
Okay, and this may be for you, Senator.
If I, go ahead.
Sure, go ahead. Yes, ma'am.
I want to hear your next question. I'd like to add on to what Tanner just said. Two things. First off, out of 1,300 nationally, let's say there are 5 in Maryland, and I have no data at all, nor access to the data, so Tanner will get us that. It's still 5 more than there should be, and that should be allowed by law. And even if you talk about eliminating violations that are happening now, we're still talking about victims, survivors, that need to be acknowledged, treated. They need real therapy. They need, and that's expensive. They need to be acknowledged, and there's a funding avenue for that. I also want to thank my wonderful chief of staff, who reminded me that there was an LGBTQ young people report in 2024 in Maryland that said that there was a poll that said 6% of our LGBTQ youth were threatened with conversion therapy, like if it didn't change, and 2% were actually subjected to it. And that was 6 years after we passed the law. So it is still around in Maryland. So please, you had another question, though.
I'd love to see the data, because
Yes.
I think that's important
Yes.
to do that. My follow-up question for you, Senator, is that, and this is coming from the opponents of the bill, they're going to suggest that there's existing laws against fraud, coercion, and abuse that could already address these concerns. Why do you think that specific protections already in Maryland law make this bill unnecessary? How would you answer that?
Thank you, Senator McKay. I'm going to start, and then the legal expert, I think, is Shannon Minter, so I will toss it to Shannon. And of course, my whole brilliant answer just went right out of my head. So we already have a law that says that this is forbidden, and yet we know it's happening. This bill is not just about outlawing it, which is already the case. It's about lengthening the period of time for survivors to be able to bring suits that would be covered through a special fund, nothing from the general fund, no fiscal note, but that would help them get their due in court. Shannon, what would you add to that?
Yeah, I think it's really important to be clear. This does not create some new kind of cause of action. You can already sue for malpractice when you are harmed by a state licensed therapist. So the burden remains on the plaintiffs at all times. You have to show harm, and you have to show that your harm was caused by the therapist doing something that violates the professional standard of care, just like in any other malpractice case. Isn't given any kind of special new protections or a new claim or something like that. It is doing one thing that is plainly within the legislature's purview, which is set the statute of limitations. How long do you have to bring that type of claim? Right now, it's very short. It's too short. I'm telling you, most of the people who are harmed by this, families come to us. They're like, my child was harmed. It's too late. The statute has run because it's set too short for this particular type of harm for the reasons you've heard about today, because these families are duped. They don't understand that this is going to harm their child. The child tends to blame themselves. So we're just giving people more time to bring a legal claim that they already are entitled to bring under Maryland law, just to be fair. I mean, people need a fair chance. You still have to prove your case, but it makes no sense to impose a statute of limitations that makes it impossible for people to reasonably have known that this conduct caused their injury.
Thank you, Shannon, if I may. So you had talked about the mechanism for funding, and it's I understand there's a 35% premium surcharge.
Yes.
On practitioners who engage in conversion therapy and establish the conversion therapy surcharge fund to reimburse the successful plaintiffs for their costs. Like, I'm having a hard time. So we've already outlawed this. But yet, we're then going to create a fund to go for somebody who is supposedly not supposed to be doing something, but yet we're going to tax their...
Right. So my understanding, and again, I'm going to defer to Tanner and the others. James, if you want to speak up. It's really clear that professional therapists are outlawed, and I suspect that a lot of them are pretty cautious about doing this. But there are also others, private entities. There may be, summer camps. There could be faith institutions. There could be others that do try to do some of this abusive behavior.
Right, but how is their insurance company going to know that they're doing something that is illegal in the state of Maryland, but somehow through a camp is doing it, so that we're going to now create a 35% premium surcharge on somebody who's not putting a sign out and not telling their insurance company that they're actually doing it? I don't know how that works.
Right. Shannon's our resident lawyer in this. Shannon, maybe you can help with this.
Yeah, no, I think you're pointing to a real issue that needs to be addressed in amendments to the bill. There needs to be some mechanism for identifying the therapist. They need they'll have to be asked, are you engaging in this type of practice? And this fund is just for therapists who would be sued and then would be unable to pay the damages. So it's gonna, most times that's not gonna be the case anyway. But I do think there is an issue that needs to be looked at to make whether this is practically going to be, how to make it practically workable. I do think you've identified a need.
Yeah, I mean,
there.
I don't understand.
Yeah.
A premium surcharge, and then like in addition to that is what is the audit mechanism? Like, when we have our unemployment insurance and we have to file, and at the end of the year, did we actually get charged the right amount compared? So anyhow.
Great question, Senator.
Much.
Thanks for being so diligent.
Excellent. Seeing no further questions from the committee, thank you very much, Madam Vice Chair and members of the panel. We'll now switch to the opposition panel, both of whom are joining us virtually. Oh, actually, so we've got Okay. I have. All right, we'll go with Lorna Henry. Coming up, we'll hear from you first, and then we'll go to our virtual guest.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Lorna Henry. I'm an attorney with PJI, a national nonprofit law firm with an office here in Maryland, which I oversee. We work to protect constitutional liberties, including the free exercise of religion, parental rights, and the freedom of speech, all of which are in greater jeopardy if this bill were to pass. And I'm going to focus on parental rights. And in doing so, I just want to point out that in comparing this bill to the one that was passed in 2018, we cannot ignore the recent ruling by the U.S. Supreme Court in Mahmoud v. Taylor this past June, when a group of parents of different faiths here in Maryland stood up against their school district and said the government cannot impose its moral and religious beliefs on their children. And the Supreme Court agreed and sided with the parents. Parents have a fundamental legal right to direct the upbringing of their children. That includes seeking counseling for their minor kids that align with their values and not being forced into counseling that would violate their religious convictions. And the state cannot require parents to embrace a particular ideological viewpoint at the exclusion of a less favored one, which is what this bill perpetuates. In addition, this bill is incredibly overbroad because it states that any effort, not beatings, any effort by a mental health or a child care practitioner to change a minor child's gender expression is unlawful. Imagine a parent with their child, and the child voluntarily has a change of heart about their gender identity, which is not uncommon. What does the counselor say to that? Sorry, we can't voluntarily help you, even if this is what you want. Is that right? What makes this bill particularly concerning also is that it seeks to criminalize something that should not be deemed criminal, making voluntary therapy discussions about gender identity a crime punishable up to 5 years. I respectfully urge an unfavorable report.
Excellent, thank you very much. We're going to hear from our guests joining us virtually, and then we'll open it up to the committee for questions. So, Ms. Bullard, you're up.
Thank you. I'm happy to be here today. I am here representing a legal initiative that works for the rights of women and girls, and also as a supporter of DIAG, which stands for Democrats for an Informed Approach to Gender. We are Democrats who disagree with gender-affirming care because we have witnessed firsthand in our families the harms of gender-affirming care. We are concerned with the rights of detransitioners. Our concern with this bill is that there's a conflation of sexual orientation with trans identification. The case of Sage Blair, who featured at the State of the Union address, which many Democrats skipped. The Democrats shamefully did not applaud for Sage Blair. That was a Maryland case. This kind of bill would perpetuate abuses such as Sage experienced. So we urge either this bill be just tabled and let alone, not move forward, or that you have an amendment to it, which I proposed in my written testimony, that conversion shall include converting or encouraging and or aiding in the transition of a child or youth, in particular a vulnerable youth, from their biological chromosomal sex to an ideational identity that is divorced from their biological chromosomal sex, including conversion and transitioning practices, which include gender-affirming care. We also want to amend the definition of a conversions therapy so that it shall include any and all practices that teach or lead children to believe that they can be born in the wrong body. This is an anti-empirical and a factual impossibility. Thank you very much for taking the time to listen.
Thank you very much. And to either of you who spoke, or it probably goes best to our sponsors of the bill, but you mentioned something about the if something takes place, it could be illegal. If a counselor says something negative, it could be it then becomes a crime. Is that what I heard?
Based on the definition of convergent therapy in the bill, which I said is incredibly overbroad, just discussing gender identity could, yes, would be a crime under this bill.
So if a counselor who disagrees with a conversion therapist says to a young person, I don't think you'll be happy doing that, et cetera, are they breaking the law? Or a pastor from the pulpit or a Sunday school teacher, if they were to say that to a youth who's considering changing their sexual orientation, is that a violation of the law under this bill, in your opinion?
Well, the bill is focused on narrowly on licensed mental health counselors, so a pastor, right.
There can be a
And so under this bill, any effort to change the gender would be unlawful, but that doesn't really speak to the primary concern. It's for kids who actually want someone to discuss it. There are people, they're parents of faith, there are children of faith that voluntarily want to change back to whatever gender they were. And so to deny that kid and that parent the opportunity to have those voluntary conversations is actually counterproductive. And it goes against really the professionalism of the counselor, because then it seeks to impose a government's ideological viewpoint on that kid rather than trying to treat them based on what their own personal desire is.
Okay. I appreciate your answer, because I'm somewhere in between on this bill. On the one hand, I never make a decision based on, not here, based on my religious orientation. I just don't think we have the right to push down anybody else's throat who we are religiously. We just say we're for example, a pulpit. You just say where you are, and the people can decide for themselves. I think when it comes down to that and relative to choice, then I would leave that to others. But if it's going to cause a misjustice, and I want to see the numbers of those who have been through this process, who felt hurt by it, et cetera, because I want to make the right decision, but I want to make it on the facts and on what I believe in terms of the opponents of the bill, and in terms of counselors who are licensed counselors, and they're on the other side of this. I don't want them to be persecuted or prosecuted. So I'm trying to get information relative to that.
And in response to that, I know there were some statements made about beatings and abuse and physical abuse, and that's not the definition of convergent therapy in this bill. The definition of convergent therapy is also a categorical restriction on simply making statements and talking out the matter with a child who actually wants to hear what a person of faith, that is a counselor, has to say. Now, what makes no sense to me is why the state would disallow that sort of treatment by a counselor to a child who wants that sort of discussion or treatment, or even parent. And so it's a very one-sided imposition of a particular ideology that every counselor and every child and every parent in the state would have to abide by. And how is that fair to the one who wants to hear the other side of the story?
And that's where I was kind of going with this line of questioning. Number one, as I said earlier, I don't want to force my opinion on somebody else's life. I will say what I believe about it, but they have to do that. But and if that's how I feel, isn't the same thing being done to those who are counselors and disagree? The same thing I'm saying, not forcing something down somebody's throat and prosecuting them for what they believe. Based on this bill, in your opinion, is it doing the same thing that I'm saying I want to stay away from? In other words, if one side is able to say what they want to say about it, and the other side cannot, doesn't that pose the scenario that I just expressed, which is how I handle it? I have to listen to everybody. In my field, I have to listen to everybody, right? And I'm kind of thinking that should be the case here. I mean, give me your opinion.
It's very, very problematic. It presupposes there's a 0% chance that a minor who has a Christian upbringing or a Muslim upbringing will walk through that counselor's door. What if you have a minor who is a person of faith? Can the therapist now not discuss treatment along their lines of faith, even though that would be in their best interest? This bill says no, you can only talk about one side. And there's people who have and entertain more than one side. So it's only catering to one ideology, and that is not constitutional.
And that's what I find problematic, because we do have licensed Muslim and or Christian counselors with practices set up, and I'm just fearful that this will, I think everybody has to have both sides, that this will limit their job if they are a licensed by the state of Maryland counselor, but a Christian counselor or Muslim counselor, and on it goes. Would this put them in jeopardy?
It would put them in jeopardy, and it would put their clients in jeopardy, because there are clients who want that perspective of faith, and they would be denied that opportunity.
So it takes away choice.
It takes away choice.
Which is how I've always tried to make it, looking at both sides. But if we look at this, it's giving no choice.
It gives no choice.
Okay, thank you. Thank you.
Thank you, Mr. Chair. Couple of things. So I think a couple of issues are being conflated here. We have already banned conversion therapy, so that's not what we're talking about here. So that's not what's at issue with this bill. Second, I think there's some liberties being taken with saying person of faith, because there are a lot of people of faith who think that so-called conversion therapy is abhorrent. So let's just be careful about terms. And then I think the third thing is this bill is completely content neutral. If you look at the definition of conversion therapy, it's not saying you can't talk about it, you can't listen to the child, however the child comes in. If the child comes in and says, I think I'm trans, I'm okay with this, or I think I'm trans, I'm not okay with this, that child can do that, and that therapist can have that conversation. What the therapist can't do is seek to change them. What they can do is provide acceptance, support, and understanding for how that child is presenting. So it is very content neutral. It is not targeting one viewpoint over another.
Well, I would first, to your first point, I would say that in the wake of the Supreme Court decision in Mahmoud v. Taylor, which strengthened parental rights to direct the upbringing of their children, I would say that there could be some legal challenges to the 2018 law, and especially if this law were to pass, which would actually criminalize up to 5 years in prison, up to $50,000 in fines, or both such actions by a counselor, which also parents have standing to sue as well. And then as to the definition of conversion therapy, and I thank you for the clarification, but the bill is not clear. It's very overbroad. It defines conversion therapy as any effort to change the behavioral expression or change gender expression. Effort, does that include just talking about it? So that's why this is going to chill speech among counselors, because they are going to be fearful that what could be considered just neutral efforts in line with this, maybe it does go over the line, and maybe they can't say what they would want to say. And this is particularly problematic with that child or parent who wants to align their actions with their religious beliefs, because it's at that point where there would be efforts to maybe discuss Bible passages and treat them in accordance with their own personal desires. And can a therapist not do that? This bill suggests that they can't, or at the very least, it raises questions. And so that's why in this current drafting and the definition of conversion therapy, I think it's very, very, very unclear.
Mr. Chair, may I follow up? So our law has already been challenged and upheld, one. And two, the case that you keep citing was about books. It's a very, very different, books in a public school and a parent's ability to take them out of that particular class. So that is a wholly distinct issue than we're talking about here. So I just wanted to make that clarification. Thank you, Mr. Chair.
In response, could I respond to that briefly? So I believe it was challenged once in 2019, and that was before the most recent decision. And even in regards to my movie Taylor, there's a case in New York, Miller v. McDonald, where the an Amish family is challenging New York's COVID exemption or lack of a COVID exemption requirement for children. And the Supreme Court just recently returned it back to the state. And they expressly said, in light of my movie Taylor decision, revisit your ruling. So the Supreme Court is signaling that that decision is stronger or strengthens parental rights and is much broader than just Brooks. It's about upholding a parent's right to direct the upbringing of their children. That's the direction of the Supreme Court at this time.
I just have another question that it could go to anybody, but I believe there's a Supreme Court case more on point that's pending right now. If I've got it right, it's Chiles versus Salazar, which is, now I don't know what the language of the Colorado statute is, but, you know, obviously it's called a conversion ban. And I studied psychology, doesn't make me an expert, but I do know how tricky it is to define a therapy, especially talking therapy. It's very hard to come up with a definition where you don't perhaps tread into First Amendment rights and religious freedoms. But I just throw that out there. You must be aware of this case. I would just say that this might, and anybody can speak to it, I'd kind of like to see where the Supreme Court comes down on this case before I would jump into expanding, restricting, or altering anything that we've done in this area, since it seems like a very unsettled area of the law. Would you agree, ma'am?
I absolutely agree. And
everybody.
And if anyone has an opportunity to listen to oral arguments, the Supreme Court, it appears, is signaling that they may actually strike down Colorado's conversion therapy ban. And I think it would be very prudent for lawmakers to see how that turns out before going forward.
Every article I read said they were somewhat skeptical. And that does not mean they're skeptical about some of the other issues that are being brought up, but they may be skeptical about the way the legislature fumbled in trying to define this therapy or how it's trying to implement it, and we can always work to improve that. So thank you for sharing your thoughts, sir. Thank you.
Okay, thank you, and I'll start with this. I don't think, and to my colleague, let me just say this. I don't think you have to be careful about saying Christians. I think we have to be careful that we say some Christians, and that's what is not often done, because even Christians are on different sides who go to church every Sunday, but they're on different sides of this argument. My main concern is not even about their choice, it's about the abuse, whether it's physical, mental, or emotional. How are we able to deal, and that's a part of this bill, right? To prevent that. But that's more of my concern than anything, is the abuse of someone because of the way they feel. And if those tactics are the tactics that are being used, then I would agree that's the wrong way to go.
And to respond to your point, so the bill would outlaw even verbal discussions. And so I'm interested.
But that's where I stopped with.
Right. But the bill doesn't stop there. And so that's why it's entirely overbroad, and it's not even constitutional in its current form.
What you're saying is that the bill doesn't just stop with the conversion therapy, it even stops with the conversation.
A conversation, and it's a misnomer probably to just broadly cast therapist discussions about gender identity as convergent therapy. I'm sure some councils would take exception to that because that is not what's going on in every situation at all. But yes, this bill would even ban verbal conversations to a child who wants to have those verbal conversations.
And I did hear the testimony of one of our colleagues' daughter, and what she was saying. I was appalled. I was hurt. I was taken aback at what she was saying. And no matter what you believe or think, no one should have to go through that kind of trauma, especially not young kids and children. I may be one place on it, but on the process and on the person's right to make that decision, I draw the line there. So I'm going to be really thinking about this and really kind of struggling with it. But I thank you for answering me, and thank you, Mr. Chair.
Thank you.
All right, seeing no further questions, thank you all very much. That will conclude the hearing for Senate Bill 950. We'll now move on to our final bill of the day with Senator James. Hey, with Senate Bill 743.
Really lost my place. I'm so glad there's a few people still in the room. Thank you, Mr. Chairman, members of the Judicial Proceedings Committee. For the record, Senator Mary Delaney James representing Harford County, and I'm delighted to be joined by the Chief of Police from Bel Air, Chuck Moore, and Rich Reinhold, who is, I hope I'm doing this right, I think you're coming in to speak for Cumberland and for Frostburg in terms of just what that those municipalities have been dealing with. This is Senate Bill 743, which we're hoping you'll look favorably upon, is asking that a work group be created to study the state laws on electric bikes. And I'm going to tell you, it seems to me I get into these sort of esoteric areas to some extent and realize that nothing is simple in life, including e-bikes and electric mobility or micro mobility. But what I'm just going to generally tell you and let these gentlemen sort of take more of the lead is that I think that we put in at least some modest legislation in 2019. Yes, we have one or two definitions in one area, and which I have in my testimony, and then we have a few statutes in another area that tries to regulate a little bit about e-bikes. But here's what's happened since 2019. There has been an explosion of the creation of these bikes, the technology that comes with it, the sales. For example, in the United States, I think e-bikes now, which are bikes that require that you have a pedal, but also has a motor. And then there's 3 different categories depending on your speed, which also I think we ought to revisit. In any event, that accounts for something like over 250% of the growth in bicycle sales. So we have definitely, where we were in 2019 and where we are in 2026 is hugely different. Secondly, we've had almost an identical increase in injuries because of these vehicles. So while I appreciate that MDOT gave you a letter of information and a couple of advocacy groups put in some letters saying, well, we've got work groups and whatnot, I've looked at these work groups. First of all, nobody's been meeting. Nobody has an agenda. Nobody has law enforcement on them. Nobody seems to have towns on them. And these gentlemen are here to sort of say, what's it like day to day to be dealing with a near 300% increase in e-bikes and injuries. So this work group is to sort of put a fire under, whoever exists who says that they're looking at this, I suggest that they're not looking hard enough, fast enough, and that we need to be doing a little bit more. And I hope, if anything, let's try to get a bill like this passed. You can modify it, you can add it to one of the groups that already exist to some extent, but let's put their feet to the fire and have some deadlines about making some progress in this area, because I don't want the chiefs of police in these towns to be picking up the pieces as they have had to do in New Jersey. Tragically, a 13-year-old child is went on these e-bikes and was killed. Now, I don't want that to be the case in Maryland. I also don't recommend that we be New Jersey that came in heavy-handed and regulated and restricted en masse. But what we ought to be is very thoughtful, very encompassing, and very proactive, and I submit that we're not doing any of those things right now. So let's get ahead of ourselves. Usually Maryland likes to be a leader. I think we should lead in this area. So for all those reasons, I hope you consider favorably this bill or some amended version of it. Okay, thank you.
Thank you, sir. Greetings, Mr. Chair and distinguished committee members. I'm Chuck Moore, the Chief of the Bel Air Police Department. For the past 2 years, the town of Bel Air and other jurisdictions have been navigating serious issues related to teens and children operating e-bicycles, electric bicycles, in reckless manner. These acts of recklessness include frequent calls from citizens for e-bike riders riding wheelies down the street, busy streets, riding recklessly on sidewalks at retail locations occupied by pedestrians, swerving towards oncoming traffic and nearly causing crashes, defiantly heckling police and fleeing apprehension efforts from our police department. On several occasions, when apprehended, these e-bike operators have been found with contraband. On one instance, they were found with a Glock look-alike airsoft pistol. The speed and versatility of these bikes make it difficult for apprehensions and empowers juveniles who have frequently congregated and gathered in groups of tens to dozens. They have committed vandalism in our parks and playgrounds and are creating much concern for the safety of the riders and for pedestrians and other motorists. They are also creating moments and instances of anger among adults, and there have been occasions where these moments of anger have escalated into actual assaults. The action the police have taken so far include frequent juvenile citations, juvenile arrest, juvenile referrals. We've taken their bicycles from them. We've done many social media posts, and we've even actually conferred with the parents about the behavior, but all of this is done to no avail at this point. And as we continue into 2026, we're starting to see an increase in the number of violations again. So we need help and support legislation to regulate these e-bicycles and e-micromobility vehicles in our community. This legislation is also supported by the Maryland Chiefs and Sheriffs Association. Thank you for your time and consideration of a favorable report.
Mr. Chairman, good afternoon, Mr. Vice Chairman, members of the committee. For the record, Richard Reinhart with Percy Public Affairs. We represent two great municipalities in Allegheny County, the city of Cumberland and the city of Frostburg. And I'm going to take a little bit of a different tack from the previous witnesses. As you know, Western Maryland is known for a great tourism destination in Maryland. Since COVID, we've actually seen a large group of folks migrating out to that particular area. They want those sleepy town experiences. They can telework now, and they're enjoying sort of the quiet relaxation of our mountain Maryland areas and communities. That surge has bolstered a new renaissance for these destinations, these communities. And it's also been a primary push for new urban development projects. In Cumberland, particularly 2 years ago, if you remember, we had the revitalization of Baltimore Street. This effort brought new streets, new sidewalks, new commerce. It also welcomed new ways of walking and pedestrians using cycles and bicycles and things like that. While that has been a great opportunity to see a new growth and rediscovery of Allegheny County, and particularly Cumberland, it also raised new awareness for city officials on how we're modernizing local regulations so that we're looking at the safety and well-being of pedestrians, but also any potential concerns that we have for the safety of the people enjoying utilizing their bikes, scooters, skateboards, and including e-bikes. I think this has been incredibly important for Cumberland the last couple of months. In fact, it has actually brought them to actually reach out to associations like the Maryland Municipal League and their folks across the pond, as we say, in Ocean City, saying, we need guidance. How can we update our antiquated regulations to make this a safer community and enjoy sort of the more bolstering opportunities for more folks enjoying the areas that we're bringing? This bill is helping provide some guidance for people, or I should say municipalities like Cumberland and Frostburg, and it's going to help a direction that is much needed in local governments and municipalities across the state. For those reasons, we strongly urge a favorable report.
Thank you, Mr. Chair. Senator, may I ask you a question, please? Yes, please. Thank you. So I want to talk about the composition of the work group. Have we really worked to make sure that there would be rural and urban and just making sure?
Yeah, sorry.
Yes, ma'am.
No, I don't want to interrupt. Go ahead.
Just making sure it's an equal balance throughout the state.
Right. When I was first approached, it was primarily from a law enforcement perspective. But, I educate myself all along. I reached out. I didn't even list all the organizations I reached out to, which is why we have some testimony from different groups. I'm very, very open to expanding the group, making sure we have a balance. That is not really my focus, is not how the membership is done, except that we have a good balance, so I'm always open to amendment, just that we are not languished at this point. I think what we've got different groups that aren't directly asked to do this, thinking that somebody else is going to do it or will get to it, but I'm having real people really now telling me across the state, we need to be actively focused on this, and I'm open to how that's accomplished. So I'm totally open to any amendments you have.
I assume you've read some of the testimony
I read it
and
all.
opposition and
Yeah.
all that kind of stuff.
Right.
I wouldn't expect any different that you've read it.
Yeah,
Matter of
but
fact,
you know me.
You probably proofread it.
I proofread it, and I'm fine with, I'm always open to amendments to adjust it, but I don't accept that people are addressing this because of what I just told you with the data. And I'm telling you, nobody's had a meeting, nobody's done an agenda, nobody's invited people to come in. They may be thinking about it. That's great. Then we're on the same page. Let's work together and come up with something that requires people to actually finish this job.
Some of the opponents have said that possibly the work group is weighted too much towards law enforcement.
I have no problem. That's how it first came to me, and I could have talked longer. I try to keep my remarks brief, but I think I tried to say I'm very open to expanding the committee members if that's not an issue for me or the people that are with me.
Well, and I tend to believe that, and this is going to end with, isn't it so? I tend to believe that public safety is the charge of law enforcement to make sure, and I tend to believe that they should have a say in what's going on and then sprinkling in some administrators and such, because they're the ones that in these towns and municipalities that have to enforce that. One of the things that, since Mr. Reinhardt brought up the city of Cumberland, a couple years ago, matter of fact, 8 to 10 years ago, the city of Cumberland latched onto a grant because it was free money. And we were going to put signs about share the road with bicyclists and paint everything on. It was so confusing to the elderly population of Allegheny County that they had to take down the signs. And so therefore, I tend to believe that as this work group goes forward, having both the administrators and then public safety are important. Isn't that so?
Yes, it is, Senator. Thank you.
Thank you, Mr. Chair. And thank you, Senator, for bringing the bill. I'm a little confused as to the focus, because some of the testimony was on youth, speeding on bikes, and then it talks about e-bikes, which we have regulated in state law, and there's, speeds that they're allowed to go and that they're not allowed to go above. So is the focus to look at all electric bikes, or is it just those motorbikes that kids are using?
Well, thank you for asking that. First of all, it's I'm calling it e-bikes, and there's also something called, what is it,
EMAD,
EMAD.
electric personal assistant mobility devices. That's for like people with handicaps, and then micromobility. Yes,
Right. To me, the first order of business is the e-bikes. I would defer to these gentlemen, but that's because this is where you're having an intersection of children, teenagers, and adults. To my knowledge, most of the other, there's only one or two others, e-scooters and things like that are generally for older people and don't seem to be the primary driver. Although, if you're going to get into e-mobility, that you can obviously expand it. But hear me out. The bill, the way it is, was to look at public safety, rules, improving awareness. If you read the last part of the bill, it couldn't be more broad, because I don't want to predetermine what drives this. What I'm aware of is that nobody has updated these rules since 2019. Since 2019, there's been a 300% increase in injuries and sales of these. And I have local governments and local law enforcement telling me, you are woefully behind the curve. Please focus on this. And they have not really been included. So the local law enforcement or local administrators, the way the prior senator said, seem to have been left out of any other entities that might take this up, but nobody has taken this up. They just say they will prospectively. I want to push the issue and say, that's good, let's do that. Let's work together, get a real focus, get a task force, make sure we have a broader focus, the ones I've brought here, and let's get some real meaningful forward momentum in this area and update our laws.
Sure, and I get that and I hear that. I'm still not understanding, because there are e-bikes that people use to get around if they, aren't strong enough to ride a bike, or they're going much farther, or there's that category. And then there's the other category of youth on motorbikes that we've heard a lot of testimony about, so I'm not clear
I think
what this
you're
is
mixing
going
them
after.
up. Right now, this is my understanding. I've got law enforcement here to back me up. There is one thing called an e-bike, okay? Right? That, and you
I'm
have
aware.
to have a pedal.
I was here when we passed
So you
that.
have a pedal and you have a
Right.
motor, right? And you either are, they go together. That's what we're dealing with. Now,
Okay,
that's
that was
called-
my question.
Okay, so I don't know what the other one you were talking about. We have motorcycles too, but we have e-bikes, we have motorcycles, and then we have bikes with no motors. Does that make sense?
Thank you.
Okay.
Sorry, seeing no further questions, thank you very much, Senator, and thank you to the panel. With that, that'll conclude the hearing for Senate Bill 743 and our hearings for the evening. Speaking of bicycles, oh yeah, actually, before we gavel out, we are going to vote tomorrow at 12:30.
Or immediately following.
Or immediately following the floor session, so whichever's first. 12:30 or right after floor session, so whatever's first. But we just got that one bill, so, or two bills.